Good morning. Actually, my friend, colleague advocate, Mr. Thirumaran wanted to explain the judgment to all those who are dealing with rent control cases. This is another issue which has to be settled yet, despite the fact that this was again and again settled. But finally, on 25/1/2022, Justice R. Subramanian seems to have given answer in civil revision petition NPD number 3056, 3061, 3062, 3063, 3067 and 3094 of 2021. This citation may be styled as S. Muruganandam versus J. Joseph. The problem was all these three, 2, 3, 4, 5, 6 CRPs have been divided into two categories and allowed certain CRPs, setting aside the judgment of the lower court not entertaining RLTOP and directed to take it on file, and the other case uphold the judgment of the lower court that the RLTOP was not maintained. So the judgment seems to be a doctrinal research thesis. A judge strained much and exhibited his highly experienced, cool-minded judgment, as usually he was when he was practicing as an advocate. And even after elevation, he was still more experienced in delivering such judgments. See, precisely to understand the judgment, you have to follow Indoor Development Authority versus Shailendra, reported in 2018 3 SCC 412. And Justice another judgment, single judgment, which did not discuss deeply about the act. Therefore, that judgment was treated as in per curiam. This now, after going through the entirety of judgment, the judgment summarized this way, instead of going to section other things. See, there are cases, the tenant and landlord relationship. Number one, tenant and landlord relationship which was existing prior to this act, the RLTOP Act. Then the continuation of tenancyship after this act being brought into effect. Then what happened? Regulation of Rights and Responsibilities of Lands and Tenants Act 2017. Regulation of Rights and Responsibility of Landlords and Tenants Act 2017. Before that, Tamil Nadu Buildings Lease and Rent Control Act was there. So there you used to file suit for RCOPs and deciding the title. If suppose denial of title is there, the Rent Control Authority empowered to decide that issue also. But here, this act prohibited that act. Here, some authorities were introduced to register the tenants' agreement. That was compulsory after the act being brought into force. So the category of tenancy and landlord relationship again come to other two categories. Number one, abiding the command of the new act, that after the implementation of the act, if your tenant was already existing, you have to register that tenancyship with written agreement. If suppose if you are inducting the tenant after this act, it is your bounden duty to register the same. Then only you can invoke this tribunal. That means RLTOP patients. So what was the answers if suppose there was no agreement or no compilation or no obeying the command of the act that you have to register? This RLTOP, that this act has been brought to force only to for collecting data of tenants within the area, so that something should be checked. But I don't think, because this power was registering power was vested with revenue authorities. They are already boarded with the work. Whether they are registering it, they are complying it, I do not know. So of course, if you have a tenant whose tenancy period already expired, then you can command by a notice that you should enter into an agreement, or you can approach the authority to compel the tenant to continue a tenancy by entering into agreement. If he failed, then you can automatically have right to evict him under RLTO. If suppose you yourselves and your tenant are much brave to disobey the statutory provisions to register the tenancy and to enter into written agreement, then this judgment says, okay, then what is the other alternative? Then after discussing section 3440 of the new act, the respectable judge held that then Transfer of Property Act 106 and 107 may come to rescue, and you have to file civil suit. But the judgment says you may not have a speedy and the rapid disposal of the case available under the new act. I can't accept that. Both are same. Even nowadays, instead of going to rent control RLTOP court, even if you file civil suit under Transfer of Property Act, automatically, if you are very vigilant in attending the cases, thanks to COVID regulations, after relaxation, you can get justice. But yes, I do admit, for getting a degree copy and going to EP court, probably there may be some delay. Same with the rent control RLTO cases also. It's all right, whatever it may be. The judgment says you can file civil suit under Transfer of Property Act, because oral agreements are approved under Transfer of Property Act. If it is not for more than 1 year, and still that such interpretations are there. If it is more than year agreement, it should be registered. That also are there. The question of admissibility of then it depends upon the lawyer who deals with the case, how to tackle these cases. But it is far better some awareness to the landlords, at least by the corporation authorities or revenue authorities, that they are bound on duty to register the tenants agreement between the parties. Otherwise, they may be land in trouble. Again, so many things are there. But at the time of filing suit, taking advantage of taking the provisions as an arm to evict a tenant under 106 Transfer of Property Act as well 107 Transfer Act, you have to categorically state that the tenant since not entered into an agreement and the tenancy was orally entered into, and after promising whatever it may be for registering the agreement and everything, he has not obliged. The plaintiff have no cause of action to approach the tribunal meant under the new act. Therefore, filing the civil suits would be one of the classic averment in the plaintiff. And court fees are not that much high comparing to RLTOP. There is flat system RLTOP, but here somewhat pro rata basis. All these things we have to take care of. Then, if you want arrears of rent, you have to file mandatory injunction directing the respondent to pay rent as orally agreed upon till the disposal of till the handing over the possession to the plaintiff. These things all should be there. You have to take then a section automatically comes under specific relief act. So all these things are there. Go through the judgment. I have gone through the judgment. That's why it took 3 days time. And today from early hours I have read it completely. So this is the crux of the judgment. And the central government wanted to introduce, which is the over. I don't think that has been placed before the parliament. Another rent control act having some different mode of procedures for landlord and tenant relationship. It's all right. Actually, you know one thing, when the Buildings Lease and Rent Control Act was enacted, that act was enacted for the purpose of tenants only, not for that is an act meant for tenants' rights, except a few rights for a landlord. Here now, this new act is in favor of the landlord, provided he register the rental agreement with his tenant. Get your tenant agreement in writing and place before the authority, revenue authority, for registering it. Then you can easily evict him. That is the procedure. Otherwise, you have to stand accused before the civil court. You can, even if you get a degree earlier, drafting of degree is consuming lot of times. It's all right. Best wishes.